Everybody, my name is Vivian Yulin and I'm the director for SCMA. Welcome to today's webinar, Kramer plus Kramer, Handling Mediation When Insurance Enters the Equation, presented by the Southern California Attorney Outreach Committee. I just want to remind you that this event is in meeting format, so we can hear and see you and you can hear and see us. So we ask that you please stay muted throughout the presentation. This webinar is eligible for 1 hour of MCLE credit and 1 hour of MC3 continuing education credit. And so if you are requiring MCLE credit, we ask that you please check in by putting your name and your state bar number in the chat. At this time, I'd like to welcome our event sponsor, Sonia Patel from Edge Dispute.
We are deeply grateful.
Hi everyone. I think there's someone not muted, but I own Edge Dispute Resolution, and we are a company providing case management services and marketing and business development to independent neutral since 2014. I've been in the ADR industry since 1997, and I litigated for about 9 or 10 years, and I came back into the business and provided case management support to mediators remotely. And again, since 2014, I was entering a marketplace that wasn't receptive to something different. And I'm happy to say that I have a number of clients who appreciate the opportunity to have an alternative way to have case management support and just somebody who knows the business. And I'm happy to say Wendy Kramer has been a longtime friend of mine and a huge supporter. And Mark is actually a client of mine. So if any of you are interested, if you're new to your practice or if you're ramping it up and you need someone to help with your infrastructure and your support, please look us up. I'm not sure how many more minutes I have, and I don't want to take up your time. I know Wendy and Mark have a great presentation. But again, if you have any questions, please just log on to our website. It's www.edgedispute.com and take a look and see if I might be able to help you guys out with your practice. Thank you.
Thank you so much, Sonia. I know that there's some. Thank you. I was just going to ask whoever's not muted, if you could please mute. I just realized I was talking this whole time and I was muted. I'm so sorry. Thank you, Sonia, so much for your sponsorship and for Edge Dispute supporting SCMA. We really appreciate it. At this time, I would now like to introduce Craig Lang. Did you guys hear what I just said or no? Oh my gosh. I was like, what is happening here? I'm so sorry. Thank you so much, Sonia.
Going in and out, just so you know, BBA, sometimes we can hear you and sometimes you get muted.
Oh,
I heard Craig Lang and that was it.
Okay, thank you. Okay, so thank you, Sonia, and thank you, Edge Dispute, for your sponsorship. We appreciate your support for SCMA, and we look forward to working with you again in the future. At this time, I would now like to introduce Craig Lang, who is one of our attorney outreach leaders and also one of our SCMA board members.
Great. Thank you, Bouvier, and thank you very much, Sonia. And we certainly appreciate Edge Dispute sponsoring our event today. Welcome, everybody. As Bouvier said, I'm Craig Lang. I am a co-chair of the Attorney Outreach Committee of SCMA. I'm also board secretary for SCMA. And I just really quick want to thank the folks on our committee who helped put this together. My co-chair, Jim Cameron, who is here, the SCMA president-elect, who is also a committee member, Jennifer Johnson-Toronto, Leslie Kushner, who I believe I saw here, Daniel Epp, who I saw here, and Sid Kanazawa, who I didn't see, but hopefully he's here. Oh, I do see that Jennifer is here. So welcome, everybody, and thank you guys so much. So I'm guessing most of the attorneys here who have been involved with litigated cases have at some point dealt with insurance coverage. I think I hear some feedback, so I think somebody might not be muted. I apologize. Either your clients have been sued on a claim that triggers insurance company, or your client has sued and made a claim that triggered coverage for somebody else. And even if this scenario hasn't happened to you yet in litigation, if you're in this business long enough, it will happen. It's the same thing for mediators. If you haven't had a case involving an insurance company, it will happen. It comes up everywhere in all types of cases. I think the most often that people associate with insurance would be like personal injury or auto accident cases. But my experience is in construction, and they come up all the time in construction cases, particularly when there's defects involved. There could be malpractice claims. I've certainly seen them in shipping cases where people either interstate shipping or intercontinental shipping, and something gets lost or destroyed. The insurance company gets involved. Obviously, there's unemployment and workers' compensation issues. Those are typically involve insurance company. And I've even seen them in cases involving intellectual property. So there's very few areas where there's not the possibility of insurance getting involved. So our hope today is to offer some advice and maybe give some perspective on how to approach mediation and settlement discussions when part of a dispute or all of the dispute has triggered insurance coverage, or even just has the potential to have insurance coverage, and you might have insurance companies involved in that way. And I'm joined today by two professionals who have vast experience in dealing with both cases involving insurance as well as mediations. And our first panelist today is Wendy Kramer. Wendy is a former partner of the firm of Kramer and Kramer, which handled a wide variety of insurance-related matters. She is obviously now a mediator and is on the panel at ADR Services. She is a former president of SCMA, having served the role admirably back in 2013. She was also chair of SCMA's mentorship program, was the ADR chair for the Santa Monica Bar, and has served as a mediator on multiple panels, court panels, which have included those in LA and Ventura counties. She was also on the board of governors for the International Academy of Mediation, and is currently the chair of that organization's mentorship program. So Wendy, thank you so much for joining us today. And I believe you have somebody you would like to introduce to all of us.
Thank you. It's a pleasure to be here. Forgive my voice. I have what's called the residual COVID cough. I went to a conference on mediation, and unfortunately, I was gifted with COVID, but we'll get through with a lot of tea. I've got all my arsenal here. But I wanted to introduce my other and better half. Mark and I met many years ago playing Lawyers League softball. I was the second base person and he was the shortstop. He ultimately came to work at the firm that I was law clerking at. I was still in law school, and ultimately we followed each other around to different firms until 1992, when Mark launched the law offices of Mark Kramer, and then I joined him and we became Kramer and Kramer, not Kramer versus Kramer. And we are going to celebrate our 34th wedding anniversary next month, and have raised two boys to successful adulthood, thank goodness. Currently have two pups underneath the table here that we've rescued and are probably going to bug us during this presentation. But Mark and I have always worked together. And so when people have asked me, how do you, work with your husband? I don't know any other way. This is what we've always done. And so at Kramer and Kramer, obviously, we work doing insurance defense, and he primarily that's been his career for 43 years?
Yes.
With a smattering of plaintiff's work as well. In fact, he's eligible for the $1 million Advocates Forum as a result of plaintiff's work. He's a member of AVOTA, AV rated. Martindale-Hubbell has been repeatedly named as a super lawyer since 2012 every year, and served as a mediator and arbitrator for over 30 years for the LA Superior Court. Recently, not so recently, about a year and a half ago, retired from the practice of law, and he's been volunteering through Resolve LA, through the LA Superior Court program that provides settlement conferences and mediations, and through Sonia's great tutelage, she has hung up his shingle as a mediator and an arbitrator, and is working privately as well. So we hope to share with you our respective areas of expertise, which overlap considerably. So I'll turn it back over to you, Craig, to start us off.
Thank you, everyone, for having me.
Yes. Well, great. Well, thank you. It's great to have you both. it's good to get a team like this. And so I jumped at the chance to join this discussion. And I want to get right to it. But before we begin, I just want to let everybody know, as you can see, we've enabled the chat function. So if you want to ask a question while the event is going on, you can. I'm hoping that we can get to some of those questions while the discussion is ongoing. I can't promise that that we will, but or that we'll get to everybody. But please go ahead and ask your question. If for any reason I don't get to your question at the beginning or during the event, then we were going to have a question and answer period at the end. So I hopefully will have some of the questions written down that maybe we didn't get to answer, maybe because it wasn't on topic, or I felt it was going to be something we'd hit later. And if we didn't, then I'll try to ask, but also you have the chance, you can simply ask again when we're finished. But like, as I said, if you hear us talking and a question and pops in your head, go ahead and free and add it to the chat, and we'll make a note of it. And if we can throw it into the discussion, we will. So, and speaking of logistics, I think for our first topic, I'd like to go into the area of logistics in the situation we're dealing with insurance companies. And so I'm gonna pose my first question to you, Mark. Before you go to mediation where insurance is involved, what is the basic information that you need to know, say as a plaintiff's counsel, to set the table for a successful mediation?
As a plaintiff's attorney, it's very important that you've conducted the necessary discovery to know what types of insurance are involved, what the various policy limits are, how many different layers of insurance there may be. Sometimes there's an excess, an umbrella, or something of that nature, and the policy limits of each policy. From a defense perspective, you really need to know all the layers involved, of course, which you would know, and which layers could potentially be reached at the mediation. So you'll be sure that you have either them appearing at the mediation, whether it's in person or via Zoom, or that they have phone contact and you can reach them during the mediation.
And so since we're getting into it, can you explain the type of insurance coverage that might be involved?
Well, for a typical auto type case, there's often policies of 100, 300, 20, 15, 30, and 5. What that means, the first number is if there's an accident involving multiple parties, any one party can cover up to the initial limit of the 15,000, for example. If there are multiple injured parties, they can recover up to the 30,000 split amongst them, however it may be. And then the 5,000 at the end of that would be for property damage. That's the minimal limits in California. There's also, of course, excess policies, umbrellas. Sometimes people have personal umbrellas, maybe linked to their homeowner's policy, or maybe for their homeowners and their automobile policy. Of course, there's commercial policies, such as trucking policies, which normally have about at least $1 million limit, and generally often much higher than that. There's CGL, or commercial general liability policies, with a single limit, and many times you have multiple layers. I had worked on a case, been involved in one involving an unnamed amusement park, and their layers of insurance coverage went on for 4 or 5 pages at least in their discovery responses. So it's important to know all these things and the different types of coverage. One other thing that's important is to know if there's a reservation of rights involved for any of the policies that may be involved in the case.
Great. So, yeah, it sounds to me like, and you mentioned that the importance of discovering, trying to learn this early on. And I think that's important to note that, even in, say, the form interrogatories, the various kinds that you can get in California, there is an insurance question in there. And that's something that's important to bring up early on. And Wendy, I'm going to pose this to you. Can you explain the self-insured retention and how that might be relevant in the context of mediation or settlement discussions?
Sure. I think the best way to explain it is that it's sort of analogous to we all have health insurance policies probably, and you usually have a deductible. And so you're responsible for that deductible to be met before your insurance is going to kick in any coverage. So that's the way the self-insured retention works. And it can be a huge insured retention. If it's a large company, they sometimes make the decision they don't want to pay a lot of money for insurance. They'd rather self-insure, and they could insure up to $500,000, $1 million. I've seen, huge self-insured retention clauses. And I think that gives them the ability to control their insurance costs, and also it gives them some say in the settlement discussions. They have control over that first huge chunk of money, and it's important to them for the reputation of their company, for controlling their business expenditures and whatnot. So I think those are the reasons why they do it. I interestingly also came across a clause that I'd never seen before in all these years of practice that was something called advice or advise clause. So most policies don't require consent of the insured to settlement, other than policies involving malpractice, things involving professional relationship. But this particular policy had a clause that even though we reached a tentative settlement at the mediation, they had to notify the insured and give the insured something like a week to respond back as to what their feelings were about the settlement. Now, that didn't mean they had to provide consent, but they had to give them time to advise them and then have their response before the settlement could be finalized.
Well, and that's good. That's kind of a good bridge into the next question. So as a mediator, when you have the insurance companies involved, who do you see as the necessary participants to have a successful mediation?
Excellent question. Everybody and anybody that has any potential to make a decision. So the list can get kind of long in these multiple party and multiple insurance cases. So obviously you want the desk adjuster. And often that person has been involved since before the lawsuit was even filed and may have a relationship with the plaintiff's attorney, and they may be getting along great or they may not. You find that out through the mediation. And then if there's umbrella coverage, obviously, if you can possibly get the umbrella coverage person to attend as well. Often they're on the phone and they refuse to actually attend, even though I've asked for it and the plaintiff has asked for it and whatnot. So that becomes a little bit difficult. If it's a self-insured retention that's involved, you typically will want to have, it could be a CEO, it could be the owner of the company, it could be a board member, it could be for example, in a HOA case, it could be the president of the board that will attend and report back to the board. And then I think the other thing to be mindful of is if there's excess exposure. So if there's a claim for punitive damages that's not covered by insurance or any intentional acts that aren't covered, the actual defendant should be present because he or she may be contributing personal funds to the settlement. Or if they're underinsured, if they haven't purchased enough insurance and they have some assets that they want to protect and they may need to pitch in some personal funds as well. So I welcome everybody to come, anybody who has decision-making capability, and Zoom has made that really a lot more effective than when we used to do these in person, because the insurance representatives are there more often than not now. So I like that.
Yeah, I've definitely experienced that as well, that with having Zoom, you generally have insurance companies, carrier representatives who are on the East Coast, don't want to come out for, say, a $10,000 claim. But then here we are in California when we start a mediation at 1, and when the settlement discussions really get going about 3:30 and they want to call the carrier back on the East Coast, it's already 6:30 there. They've gone home and there's no there's no way to reach them. But if you have them on, if they have the ability to log online, I think they're more likely to do that. And I've noticed as well that they'll stick around because obviously they know where we are in the settlement discussions, and they know where, whether they need to, get themselves involved or not. I got an interesting question, and I'll direct it to you, Wendy, but Mark, if you want to pipe in too. Joanne Selleck asked, as a mediator, what can you do when you have, say, insurance company, I assume she means insurance company representatives who refuse to attend the mediation or decline to attend? They claim, well, we're not a party. And, when we're dealing in certain court cases where parties are required to come, but obviously the court has no power to compel them to come. And if you have any thoughts on, how you get them involved in the mediation when maybe they don't initially want to.
You have to cajole, honestly. You don't have any power to order anybody to attend. especially in private setting. It's completely voluntary. And so what I do often is if I find that there's a necessary party that's not there, I will just cajole the people that are there to please have them call in. They don't even have to, make it easy. They don't have to Zoom. They could put their cell phone on speaker and just hold it up and we can have a conversation. And I've been able to get people to participate and then say, okay, send me the link, I'll come in, and so you just try to use your powers of persuasion as a mediator to get everybody there. Would you agree with that?
Absolutely agree. And ask the defense counsel to help out. I definitely, and see if they can get them there. And that's what's important.
Okay, and I've got, I think, what a follow-up to that. This is from Lynn Bassis. I hope I pronounced that right, Lynn. Do you insist that everyone, including insurance rep, be on camera? And this is in dealing with obviously the online mediation.
No, we really don't insist that. And sometimes, often you hear my camera's not working or having a problem with the video. And you can joke about whether they're
having a bad hair day,
t-shirt, shorts, or whatever reason, but I haven't insisted that.
Yeah, I encourage it. I'll just say, it's more, I feel better not talking to a blank screen, but if you have a good reason why you can't turn your camera on, that's fine. We'll just cope with it. But you can't force somebody. And some of them, they claim, that it's their company policy that they're not allowed to turn their camera on.
Yeah, in fact, I've had some cases where they say, say I typically use Zoom, and they say, well, it's our procedure, our policy, we don't have Zoom installed in any of our office computers. So they, and they don't want to do it on phone. They don't want to do it on their phone, so they just call in. But like you said, it's better than not having them participate. So I agree with you on that. So let me jump into it. Another topic here, Mark. I'm going to start with you. You may have heard the phrase, "the cap is off the policy." Can you explain that and what the significance of that is?
Well, generally it is where it was a prior policy limit demand. Sometimes you see policy limit demands that start long before a lawsuit is filed. But often a policy limit demand, whether it's via 998 or simply via letter or even orally, although that's pretty tough to document. And many plaintiff counsel take the position, and it's certainly possible that if they made a policy limit demand at a certain point in time and it's not accepted by the insurance company, then the quote unquote, the cap is off the policy, meaning that if the case then goes forward to trial and there's a verdict in excess of the policy limit, that the insurance company would be responsible for it. It's not an open and shut thing where it's just black and white that if they didn't accept the policy limit demand, that would open the policy or take the cap off, as you put it. It depends on what was reasonable at the time and how much information was available and the status of the litigation, what discovery had been done or not done. Obviously, if you have a clear liability case with a wrongful death and it's a 1530 policy and they ask for the 15,000 and years go by and it hasn't been paid, that's one that may well have the cap off the policy. Other times, though, there's a liability question, or they're just not, that the insurance company doesn't have enough information to make a decision as to what the injuries are worth, shall we say, or verify the injuries, or if they were caused by the particular accident or something of that nature. And that's that in a nutshell, I guess we could say.
Well, and so Wendy, let me turn it to you. How do you manage the negotiations when there are allegations of bad faith?
I think it's important to go back into the history and find out when was the initial policy limits demand made, and some of the factors that Mark was mentioning, to really question and explore whether this really is a legitimate claim or whether this is something that they're just bandying about and it really has no teeth to it. So find out if there's what the relationship is between the insurance adjuster who was handling the case when the policy limit demand was made, or the defense attorney. Did it go off the rails? Is there some sort of conflict just between those people having nothing to do with the lawsuit? And then through the questioning to find out whether those factors really are legitimate. It may be that the policy limits demand was made, as Mark said, before the insurance company had an opportunity to subpoena all the medical records, get a deposition of the plaintiff, get a defense medical examination in a personal injury case. explore all the damages in any kind of a case, whether it's a, water intrusion or, construction defect or anything. They have to have had a reasonable amount of time to do all of this. And then the policy limits demand has to have been left open for a reasonable amount of time. So all those that reasonable is a vague term, right? So it's not a slam dunk that, when people are, rattling that saber that, the cap's off the policy and we're going to sue for bad faith. Usually it dissipates through the mediation and you find out there really isn't enough meat on the bone to support it. And now we get down to talking about the real damages and what they are.
And I just want to add, and sometimes it's a cost benefit analysis by the carrier. Sometimes I've actually seen them where they will come in and pay something at a mediation of some extra contractual money on top of their policy limit because they realize, I know I had one where I think it was very questionable whether the cap was off the policy, but they actually put in an extra $100,000 because they thought it was going to cost them more than that to defend the bad faith lawsuit or the cap off the policy lawsuit, whatever you want to call it, going forward. So they did, in that instance, pay extra money. And sometimes they make that decision based upon what the
Cost of defense.
cost of defense of defending the case would be, even if they think they have limited liability in that regard, at least.
Yeah, I think cost of litigation is always a factor, I think, to have a mediation, I think, and obviously there's no exception when you're dealing with insurance companies. And that, brings up an interesting thing because you have, when you're an attorney, obviously, Mark, I'm directing this to you, you're an attorney, you have a client, they have coverage, the insurance company is likely paying the bills, they're possibly the one paying the settlement. That kind of creates an interesting relationship. And can you explain the significance of it's a tripartite relationship?
Well, it's normally when, say, a typical auto accident case, excuse me, you have the insurance company that you're reporting to if you're a defense counsel and the insured who you're defending. It's called a tripartite relationship because both the insurance company and the, insured are your two clients. Your primary and most important duty is to the actual client, the insured in that instance. And you have a duty to keep both informed of what's going on in the case, what's important in the case, any developments that merit their attention, that sort of thing. However, there's always, not always, but often potential conflicts involved. And the one thing you cannot report to the insurance company is something you learn from your client that may eviscerate or damage their coverage of the defenses. For example, in a simple auto case, if you learn from your client somehow that they weren't the one actually driving the insured, but instead they loaned it to someone who's specifically excluded in the policy, well, if that's reported to the carrier, obviously they're going to say there's no coverage for it. And so that's something you wouldn't be able to report. And that's involved that most important thing, you just don't report anything that will adversely affect their coverage.
Okay. And then Wendy, as a mediator, from your perspective, does this situation, do you see any ethical dilemmas that it might pose for you as a mediator? And if so, how would you address them?
I think most often when I see it, it's when a defense counsel, and by the way, obviously there's privately retained defense counsel who are billing insurance companies by the hour and all their costs and whatnot are being passed through to the insurance company. And then there's what we all know as house counsel operations, which have become very prevalent since, the 1980s, late 80s, 90s, where the defense counsel is actually employed by the same insurance company. And so that presents a different kind of dynamic as well, that as a mediator, I think you need to be aware of. So point being is that to gently remind the defense counsel and the insurance adjuster of the obligation to, that this is about this particular defendant. And, that happens sometimes in pulling the defense counsel away from the insurance company and clicking them on Zoom into a breakout room, or we use cell phones to communicate. I have defense counsel who will text me that they're having difficulty. They've made recommendations, and they're not being listened to, and help me out. And, so you just find ways to communicate with the people that you're trying to help solve their conflict. as best you can as their mediator.
And also, you have the situation of, you have, say, when you have parties where a party is both a defendant and has an affirmative claim, so they might have separate counsel, one for defense, one for the affirmative claim. Does that present any issues as well, or is that just a similar situation, you'd say?
You want to answer that? I think it's similar to me.
I think it's very similar. You have to deal with both sides. They may not want to settle part for another reason related to their own claim.
But then you get into the whole, way that you mediate. You're looking at their interests and you're doing active listening and you're trying to get to the heart of it and lead them past.
What's really driving the litigation at that point?
Yeah, and I think in some instances, and I'm just talking from my experience, and tell me if I'm wrong, but that sometimes you may in some ways have to act as a mediator between those two sort of competing interests. And that's when you have them aside, you don't have the other party in the room, and you're just saying, okay, how are we going to balance out the two interests, the insurance company's defense and the insured's affirmative claim, and how are we going to balance that out? And then you have the situation where you have, say, multiple defendants with multiple insurance carriers. I obviously in construction will have cases where there's multiple subcontractors with different trades on a construction project, and there's defective work all around. So you've got multiple parties, and everybody, every defendant has a different insurance carrier. So I'm going to ask both of you. Mark, I'll start with you though. But Indy, I'm going to ask you the same question. Does that change the dynamic to you as far as the settlement and how you're going to approach the settlement?
Well, it definitely can. I mean, sometimes you run into, as you said, in a construction case, you may have 20, 30, 50 defendants or co-defendants, however you want to put it, because there's often a cross complaint, there's an initial complaint, and then, as you know, cross complaint that names everybody under the sun.
Yeah.
And sometimes you get an issue where one party, even though they have much more, let's say they have a bigger pot to pull from, bigger policy or what have you, their liability is limited. So we're not paying any more than so-and-so, even though we have the ability. And other people will wait. We've got, obviously you're now arguing about liability amongst them. And sometimes you realize occasionally you can get people to let's settle with the plaintiff, we'll fund it, and then we'll work it out later. Often that's difficult to sell, but sometimes that does occur. Anyway, and that's just important. Sometimes there's a dynamic, which I know Wendy can talk to. She's had to do this sometimes where you split them up at all. Typically, traditionally, I think a lot of defense in construction cases, for example, all the defendants would be in one huge room talking and working. And sometimes that can be counterproductive, as I think Wendy can explain pretty well. Other times, though, they're just split up and, there's this team and that team in one room and or in that breakout room as it is nowadays.
Yeah, I can chime in on that because a lot of my work involves multiple defendants. And I've sort of, through trial and error, developed some techniques that I think are useful. Oftentimes, as Mark said, when you greet them now, especially on Zoom, you have more control over who's going to be with who, right? So they may say to you as the mediator, we've all decided we want to be in the same room. And I just, on most occasions, find that completely counterproductive. And so I will, in a nice way, say, well, let's start out in separate rooms, and then I can always click you guys together. And then I call it divide and conquer, right? And I can talk to each carrier and their defense counsel separately. Each one, in looking at the same facts, the same injury, if it's a personal injury case, the same water damage, whatever it is, they're going to have their own experts and their own opinion as to the range of reasonableness of what their settlement offer should be. And it can vary wildly. State Farm Insurance may think the case is only worth X, whereas Progressive will think it's worth double that in total. And then you get into them arguing about what their respective share is. Well, they haven't even agreed as to the value, right? So I try to keep them separate, and I've had some success lately in doing what I call blind negotiations, where I ask them to just tell me what they want to offer each round. because they've assessed what they think their settlement value is. They should dole it out in a reasonable way. I add it together. I'm the only one that knows the total sum that's being presented to the plaintiff. I get a counter demand, and then I go back to each room and I get more money, and I keep it going like that. And then I give them the opportunity to come out of the blind negotiations at some point if they're very uncomfortable about it. Understandably, they want to know what the other defendants are doing, and they've already decided, if I'm only going to pay a third, they should be paying 75%, or whatever their opinion is. So I try to take that out of it and just get to the actual money that they've allocated towards settlement, and total that together and get the cases settled. It works. And at the end, they're really happy, but they're very uncomfortable during the process. So you have to really babysit and coach and keep them at it. It's difficult.
Yeah, and I can certainly agree. I've had situations where one or more parties insist on knowing what someone else is offering. And I kind of what you said, Wendy, I try to bring the focus back to, well, where do you value this case? So that's not as important. And then you can always, as a good thing about a mediator is we have this confidentiality to say, well, look, I can't talk about that right now.
They told me I can't.
Just as I'm not telling them what you're putting up,
Yeah.
they're not telling me. So let's, and then at some point, like you said, you lift the blind once it seems like everybody's comfortable at sort of the range they're at. And that usually helps kind of get the final, pin.
And just briefly, I had one not too long ago where I laid this plan out of doing blind. Everyone said, nah, I'm not comfortable with it. And I said, okay, we won't do it. 3 rounds in, they said, you know what? We think that what you told us at the beginning is a good idea. I don't want to, don't tell them what I offered. And we went into the blind thing and we got it settled. So It's flexible.
I do think it can be very helpful because Craig, as I'm sure you've experienced, sometimes particularly like in a construction case, you may get, well, we're never paying more than defendant X.
Mm-hmm.
And that can be a stumbling block, shall we say.
Huge.
Right. Absolutely. Absolutely. And I got a question from another question from Joanne Selleck. And she was asking, in large multi-party cases such as construction, do either of you have any tips for mediators where individual defendants are settling out, but that's obviously hindering the resolution of the entirety of the case?
You're settling out. With,
I find it actually puts pressure on the remaining people to settle. So I personally, my experience is that the converse is true. If I start saying it looks like party A and plaintiff, they're carving out a settlement subject to good faith, order from the court or stipulation, that seems to motivate the co-defendants to get real. But I don't know if that's been.
I think
experience.
that can, or just. I just would want a discussion about the good faith and whether they think they can have an excellent chance of getting, or if anybody's going to oppose it.
Yeah, I think that's a good important point, is the good faith, the good faith settlement. That's obviously an issue, and like I think Wendy is right. I'm trying to think if I had a point and I've forgotten, but I think it seems like, I agree. I think that generally once parties start settling out, in my experience, it usually gets easier. There might be somebody who maybe that's an issue for them, and and I think it's different for each situation is the reason why. So I don't know that there's a hard and fast rule you say, well, you can do this, but I think generally you can at least frame it in a way of, well, they're out of the fight now and you're still going to be in it, and it's like it's just going to be a bigger burden for that party that's still in. So that's motivation, I would think, to settle.
You often have to consider that now you may be the one left holding the trial bag, so to speak, and although you be pointing at empty chairs, you're the one funding everything and having to carry the burden. Right.
We've talked a lot about the mediator's role and the role of defense attorney when a party has insurance company. So this is for those plaintiff attorneys who are here today. And what advice do you have for them about how to best get a settlement at mediation when you have an opposing party or parties who have insurance coverage?
Do you want to lead off?
Go ahead, start with you, Mark. Yeah.
I just think the most important thing is that you make sure that you've provided in an adequate time frame all the information that you have pertaining to particularly damages. It's a very tough place to start when defense counsel, for instance, comes in and thinks the plaintiff's medical bills are X, and it turns out they're 3 times X. And the plaintiff counsel, oh, well, he just had this treatment or
surgery. I had a case, I don't mean to interrupt you, but I had a case where somebody walked in with a neck brace, having just left the hospital, having a cervical fusion.
Yeah, the plaintiff counsel needs to realize that you've got to get it to the defense counsel. Sometimes they send them directly to the carrier as well, any information they have, but the defense counsel needs to get it to their adjuster and any supervisors, and it goes up the chain, as some of most of you probably know. But they need time to evaluate it, review it, evaluate it, and that'll affect the money that they're allocating or allowing, or the authority they're giving for a settlement. It makes it very difficult if suddenly it's, they had 2 surgeries that nobody knew about, and you hear about it the first time at the mediation. Well, obviously the carrier is not going to have time to evaluate it properly and to take that into consideration and the money they're willing to offer to try to resolve the case.
That leads, I want to interject
Please
something.
do.
I think that one of the biggest misconceptions I find, or frustrations, let's say frustrations from the plaintiff's bar when we are in mediation is that, on their side of it, they may, if it's a personal injury case, they've had some lien doctors, they may have relationships with them, and they sort of already know what they're going to have to pay back in medical bills. They have their cost sheet. They know what they've spent on filing the lawsuit and the depositions and whatnot, and they have their client. And those are the decision makers, right? And so it's very simple compared to the insurance companies, where it's the bureaucracy. And it's a hierarchy of decision making, and those people can be spread across the country. They could be across the pond in London if Lloyd's of London or some other firm like that is involved. And so plaintiffs get frustrated because in real time in a mediation, decisions can't be made just like that on a dime. But they need to understand, the insurance adjuster may have anywhere from 80 to 150 active files. Not a job I'd want to do. Just moving parts all the time. And this is just one of those claims. And everything gets roundtabled and it goes up this whole chain of command before decisions are made. If in a larger case, the desk authority of the adjuster is not enough to solve the case. So they, like Mark said, need to get don't hide the ball, get them everything they need, get it as much as 2 weeks to 30 days in advance of your mediation. If you weren't able to do it, call your mediator, postpone the mediation. There's no point in having it to be an unsuccessful and unproductive meeting.
As Wendy's saying that, there's just so many layers. Sometimes an insurance company, and they have roundtables, and on bigger cases I've had, we're leading up to trial, I had, 4 different roundtables over the phone. It was before Zoom was going wild, but where they, we had vice presidents in the insurance company and 3 supervisors above the adjuster, between them and the vice president. They were all on these phone calls and wanting to hear everything, learn everything about the case, and so on and so forth. And all that went into what the offers were going to be. And, how are you going to be able to get that evidence in, Mark? Well, yes. And how are you going to do that? And they just need to know what's going on. And so they can properly evaluate it so they can give you if you have a case you think is worth an awful lot of money, you want to give them the ammunition, the adjuster and the people above the adjuster, to properly evaluate it. Their files, as they say, they have to paper their file. And, you may tell them something orally, but if they just don't document it, later on their files can be looked at. Well, why did you pay this much? We don't see any reason to do it. So you've got to give them the ammunition that they need to get the right dollars ready, shall we say.
Yeah, and I think this is a general theme, but I would say it applies. I would say in any mediation that having last minute information, throwing things at the other party, whether you're plaintiff or defendant, is never really conducive to settling. I mean, we sometimes settle even when that happens, but I can rarely think of a situation where that actually helped further settling. And I think when you're dealing with insurance companies, it's even harder because the people who are going into the mediation on behalf of the insurance company, they're generally given, they're it's usually from somebody, in their, like you said, a committee basically that have sort of given them the authority or the justification for, how they're going to settle or how much they're going to settle for, or what range they might be able to settle it at. And throwing something at the last, at the time of mediation day, even the day before, kind of usually generally throws a wrench in that. So, it's always, I think if our theme to anything to come out of here today is just, it's important to share as much information as you can about your case prior to going to mediation, so that the parties, so that your opposing parties is as informed as possible, can make as informed a decision as possible on how to get, and that should be conducive to getting a settlement.
One thing
Go
to
ahead.
add to that is, Mark and I think both agree on this. We strongly encourage non-confidential exchange of mediation briefs. If you have something confidential that you want your mediator to know, just send a separate email or a separate brief, but exchange the roadmap of your case and how you're going to prove your damages with the other side, and do it well in advance of the mediation. And that's a really effective tool. Write a good brief.
Yeah, I agree. And let me ask you, Wendy, since you are just speaking, I'm just going to ask you about, you've got this cocoon of mediation and confidentiality that we've rushed on briefly. How can we use that to get information that maybe parties to councils aren't prepared to disclose, at least at this point in regards to litigation, but hey, we're in mediation?
Well, I mean, there's two levels of that. Sometimes there's material that if it's disclosed, even if it's in the mediation, it's then going to become part of the discovery, So there's just no way around it. But I mean, California has really strong confidentiality laws. And if you label things that you're exchanging for mediation only, I think that's helpful. And again, like I said earlier, if you have something confidential that you don't want the mediator to share with the other side, just be sure to let them know that. I start off every mediation after I've read a brief that's marked confidential by asking the parties, what in this brief do you not want me to share? And often I say, it's really well written. I don't see anything in there that seems like a big surprise or secret. What do you think? Maybe send it over to the other side. Well, let me read it over, and then they will do it, and or they'll take a sentence out or this or that or the other thing. But with information, for example, in personal injury cases where there's sub rosa, and they have to make a decision. Are you here? And they haven't disclosed it yet, but they've been following the individual, and they have film showing that the person can do things that they claim they can't do, or they have social media or any number of things that impeach the plaintiff. If you're here to settle the case, if you're not going to share that with the other side, I can't help you. If you want to go to trial and surprise them, great. But that's not what we're here for today.
But I do want to say, though, that sometimes you have something that
It's gold.
impeachment that may be rather devastating to the other side at trial, and you don't want to share it because you know that they can take steps to lessen the impact of it. But you may be able to share it with them. If you have a good mediator that you trust and everything, you can share with the mediator and let them know that they can't share it with the other side, but they can let them know that this defendant or this plaintiff, whatever it may be, has something that's going to be extremely damaging to your case, and you really should consider this offer or making a higher offer, whatever it may be, depending which side it is, because they do have this and so on and so forth.
Yeah, that's an excellent point. And if they, I'll ask them to script me, what is it that you will permit me to say?
Sure. Yes, and I've been able to use that in litigation sometimes. It's certainly MSCs that's come in handy, and it's also worked at mediation sometimes. And it just depends, because some people just don't, on one side or the other, they don't believe it. Oh, they think they can get around anything, but eventually they may find out they couldn't. So.
Well, very good. Well, that ends my questions. I didn't know, I do have several questions lined up here from our audience, but I wanted to know if you guys, before we get to that, if there was anything else you wanted to add, any other point that we might have might have missed.
Just what if, oh, go
I
ahead.
just wanted to mention that we didn't discuss about reservation of rights. That's
Oh, yeah.
something you also know, that's now in the standard interrogatory questions, the form ones. But a reservation of rights, of course, in California, the duty for an insurance company to defend is broader than their duty to indemnify. And sometimes they will be defending a case, but they're doing it under a reservation of rights. Basically saying that as discovery develops, we may feel that there's no longer coverage, we may be pulling out, or we may reach a decision that yes, there is coverage and let you know about that. But sometimes that is also something important that a plaintiff counsel will want to know. Of course, the defense counsel would know that. And that's important for both sides to be aware of and react appropriately.
Well, very good. Oh, that's a good point. For that, I'm going to say we're going to finish with the discussion part, but like I said, I have several questions. So if anybody has any other questions, please put them in the chat as well. And I do, before we get to that though, because this, ends the main part and some of you might be leaving us, hopefully you'll stick around, but I just want to give a quick plug to, SCMA, who provided this event, and we're hoping to provide more in the future. And for those of you who want more in the future, one way you can help make that happen is you can be part of our organization. And in addition, you can participate in our members only events if you want to become a member. So, you can go to scmediation.org to find out how to become a member. You can also reach out to me or to our great director Bouvier, or anybody on our outreach committee for more information. But now I'll go to the questions. And the first one I have is from Jim Lingle. He wants to know, what do you do when the plaintiff client wants to settle? Say there's an offer, the plaintiff wants to settle, but the client wants to settle, but the attorney who is on contingency does not want to settle. I'll start with you, Jim.
It's all the time.
I think the client's the boss. They need to realize that. You can help out discussions. Sometimes the attorney will ask you, usually it's the reverse, where the attorney thinks it's a good settlement and the plaintiff may not think it's that good a settlement. And then you have to talk to them about the cost involved and the dangers of going to trial and the inconvenience, et cetera. But maybe you can gently remind the attorney that they have a duty to their client to, follow their client, and they're going to probably settle this, but the client may relieve them of their duty if it doesn't get resolved, if the client's dead set on resolving it at a certain figure that's been offered.
And also, I have this situation where there's certain plaintiff firms that I call them two-steppers, where they really treat the mediation as a time to discover all of the points that are being made and whatnot, but they really aren't necessarily wanting to settle. They want to continue to litigate and take it up to the courthouse steps. They think that's how they're going to get the most amount of money for their client. And sometimes maybe that's true depending on the insurance company, but I feel like I have a skill set, and I know Mark does too, that we can really find out the day of the mediation what the top dollar is that's going to be paid, and it's not going to necessarily get any better. So I've had situations where I can tell the client wants to settle, but the plaintiff's attorney is saying things like, sometimes we don't settle on the first day of mediation, but Wendy will follow up or Mark will follow up, and, and we'll keep working on it, yada, yada. And lately I've been interjecting and saying, that's true. I will, but let's not. Let's do it today.
Get it done.
And let's get it done. I really feel like Ms. Smith is looking for closure today. She really wants to get this behind her. I had a gal burst into tears the other day, crying, saying, yes, please, let's get this settled, So maybe I'll never see that lawyer again, but we got a good settlement for her, and that's what she wanted.
Yeah, I think that's an important thing to point out, is that, like you said, the client really is that they should be the controlling party. I have a question from Lynn Basis again. This is a follow-up to the comment you made, Mark, about the situation where certain defendants are settling out in a multi-defendant case. We talk about the pointing at the empty chairs and who's going to carry the financial burden. So the question is, do you share the info regarding the settling parties' belief or discussions about the ability to obtain a good faith order from the court, or is that confidential between the settling party and the mediator?
I don't, I mean, certainly confidentiality applies, but I think that the other attorneys would assumptively be sophisticated enough to know that if they're settling out, that they're going to want to, it's going to be subject to good faith. So I think that you would probably discuss it with both sides, because they would anticipate, they may say, well, they're never going to get this approved by the court. And so that might be part of the discussion for both sides, and to take a look at the non-settling parties. They may want to talk to you about why they think they're never going to get this approved as a good faith settlement. And you may want to have a discussion about that, because that will affect what they're willing to do and their remaining standing in the lawsuit, shall we say, or their exposure.
All those arguments are going to be in the motion anyway, right? So
Correct.
they're going to become public.
Well, and I think, and I mean, I don't know if this is what the question, but the way I read the question was, I mean, the just even discussing the potential of a good faith, whether someone's going to oppose a motion for good faith settlement. I mean, that's obviously a procedural thing. So you're not really breaking any confidentiality when you're just saying, hey, you're going to have to go through this procedure, and do you expect that they're going to oppose you, or vice versa? Or, you realize they're going to have, they're going to make a motion for good faith settlement. Do you think you have the ability to stop that through some sort of opposition? And if because then if the idea is, well, no, I really don't think we can, we really don't have that stronger grounds, then that's space to say, well, this is maybe then the time for you to go ahead and get, settle your case out too, so that we can, you can get out of this predicament. So another question brought by somebody said, no need to mention who it is, wants to know, if case settles and you are documenting on a term sheet prior to formal agreement, is it also important to have the non-party insurance company that is funding the agreement also sign?
I don't understand that sounds like court work where you have, you're using propers or?
No, I think the question is.
I'm 100% on Zoom and nothing's.
Yeah, if you have
I think what you're talking about is you're settling, Mr. Smith is settling with insured of State Farm, and whether or not State Farm needs to sign the agreement as well.
Well, I think it is to so say that, like, say Mr. Jones and Mr. Smith, say Mr. Smith is the defendant. He's, his insurance company is going to pay Mr. Jones. Does his insurance company have to sign the settlement?
I think the defense counsel can bind the insurance company. Most insurance adjusters will refuse to sign anything. It's been my experience.
Me too. Yeah, I think generally the best you can do is just you can get assurances that, if you're there and the carrier saying, look, yeah, obviously we're going to pay, we have an obligation to, this client. So I have another one from a question from Jessica John. Do you have any suggestions for overcoming impasse regarding a party's liability when they don't want to accept any more than a certain percentage of liability, or when the parties seem too far apart, to encourage the parties to come back to the table? So it's really just about impasse, where there's, when you've reached an impasse, what's, do you have any suggestions on that, or any creative solutions?
I guess I would start out with, if you're at the point in the mediation where you've already explored all the legal arguments, and you've already explored all the facts, and you've already exchanged any information, and you're just in the settlement negotiations, and so it's just purely money and you're just too far apart. That's how I understand the question. Maybe it's brackets. I mean, I think brackets are extremely useful. Some people will refuse to use them. So that requires some education and coaching to find out. When they say I don't like brackets, I usually say why. And sometimes I've gotten bracket followers now, because I've explained why they're useful and they now understand it, and I help them create them. And so now it's not this big, unknown thing where they just don't feel comfortable with it. Even if they don't want to use it, you can use different words. You can say, well, what if they offered X, and, would you be willing to offer Y? And don't use the B word, don't use it because people get freaked out about it, or use parameters, or be a mediator's bracket. Look, I think that if I could get you guys to do this and that, then we could keep going and get past impasse. Any further thoughts?
I agree.
On that?
And it's just reviewing everything and, tell us about what you think is going to happen at trial and that sort of thing, pointing that out and cost and other factors, which
So-
may have already been gone over
Mm.
ad nauseum, but still bringing it back to that. And hey, if you don't settle today, or you want to impasse, this is what's the future holding for you.
And finding out why they're feeling so impatient. I mean, I just find sometimes on Zoom in particular, because they haven't had to drive anywhere or whatnot, they just, they're in hour 2 and they're like, we're not making any progress, we'll just go. And I'm like, no.
Yeah, and then you get
We're
it
not gonna-
settled.
you have to keep them at the table, you have to coach them, talk about summer vacation, whatever, change the subject, anything to get them back into a frame of mind to stay there.
Well, and I got a question from Mark Bunham, and Mark, I'll direct this to you if you know. I don't know if it's something you'll know, but its question is: in California, doesn't the issuance of a reservation of rights by the insurance company trigger Kumis counsel rights, which is something the insurer wants to avoid?
Not always. It's governed by California Civil Code 2860, and there may be a reservation of rights, but I don't believe it automatically triggers the need for Kumis counsel or for a carrier to provide Kumis
Can you
counsel.
explain what Kumis is for those that don't?
Kumis counsel is when there's a clear conflict of interest between the insurance company and the insurer. Then the insurance company has to pay for what's called Kumis counsel or private counsel for the insured, who the insured can select, the insured can select, but within certain parameters. For example, I think it's 5 years or 10 years in defense experience that the attorney would have to have. They have to have malpractice insurance, that sort of thing. And then the carrier would have to pay for that counsel. And that, as I said, that's governed by California Civil Code 2860.
And I have a question here from June. And June, I apologize because I don't think I can pronounce your last name, but I think this is, I'm gonna direct this to Wendy. Do you have any guidance for a situation during a online or Zoom mediation where you feel it would help settle the case if you could just chat with plaintiff's counsel alone, but yet the plaintiff always has to be present or always is present? What kind of advice would you give to, or what would you do if you would like to give the plaintiff's counsel some feedback, regarding the case or the client?
Yeah, I start out my mediations at the beginning, always giving and getting the cell phone number of every participant, except for the plaintiff themselves. Especially if the plaintiff is in the room with the plaintiff's attorney, then, I don't get their phone numbers. But, and then I also start off to say when I'm in the plaintiff room, to the plaintiff and their client or clients, that there may be some times when I will need to talk to your attorney privately. And I say something like, it's not that we're talking about you behind your back. It's that this is why you have this great lawyer, is to protect you from some of the annoyances and whatnot that goes along with negotiating a settlement. So please don't be offended if I ask to borrow your attorney. And he or she may ask you to wait in the conference room or whatnot. And they go, oh yeah, okay, no problem. So if you set the table that way, then when it comes up, you can do that. You can also use texting. I'll text the plaintiff's attorney and say, is there any way I can talk to you privately? Can you, get out of the room? And they'll write back, yeah, give me a minute. I'm going in the kitchen, and I'll call you from the kitchen, and so they'll find a way to speak with them privately.
I do the same, and letting them know they can kick me out at any time, because the plaintiff or client or multiple clients can talk with their attorney without me being present. And I let them know the reverse may happen, where I need to talk to their attorney, and so they're not bothered with the legalese or whatever it may be. And it's in my experience that some attorneys want to be in there with their client the whole time, and other attorneys will let you know, or you'll find out that they don't want their client to hear any of the discussion about how much, the defendant X is offering. They want it be private, and then they'll tell their client about it.
Kind of to steer this back to our topic with insurance, I'm trying to think if I've ever had the situation, but has it ever come up? And if it has, can you, what advice would you give? Say where you maybe want to talk, say you've got the attorney or multiple attorneys, insurance carrier, and rep, and the client all in the same room, as it were, and say you only want to talk to like the insurance company and the attorney, or the attorney and the client. How would you handle that situation? Do you think it's at all different, or?
For me, it's texting. to John, I need to talk to you and so privately. How can we make that happen? And we work it out that way. So I just always, the cell phone has become a tremendous asset in Zoom mediations. I don't use the chat function at all. I just text. And they'll text you and say, please, put me into a private room with so-and-so, and be aware, by the way, when you have multiple insurance companies too, this didn't come up in the main discussion, those insurance adjusters often know each other and have been working together since day one. And even if you have them in separate rooms, whether it's live mediation or on Zoom, they're talking to each other. They're texting one another. So be honest as the day is long.
Yeah,
You're gonna get caught.
Yeah, and you often in a lot of cases you might have the same company or umbrella of companies, in the same case, representing different defendants. And I've literally had cases where we're down to it's like down to 2 defendants and they're both the same carrier, but they're still arguing about who's going to pay how much on behalf. And it's like, you guys are part of the same company, but it's important to them because they've got to put it on paper, like how much they paid on this case. So,
right. And it could be important to their clients for
right,
the ratings,
rates,
et cetera,
yeah.
and the underwriters for the next renewal, that type of thing.
right.
So they may take a very hard line that, well, my client, even though they're both, shall we say, State Farm or whatever, well, my client's less responsible. So
Yeah.
we're not mentioning it.
I've seen that happen. Well, thank you guys both. It was great to get the great duo here. I appreciate everybody coming. I'm out of questions, so I'm gonna end it at this point. But again, I thank everybody for attending, and keep an eye out for our next event. And everybody enjoy their summer.
Thank you all. Thank you, Craig.
It's been a
Great job.
true pleasure.
Thank you.
Thank you, everybody.
Thank you.
Bye-bye.
Bye-bye.